Good evening. My name is Abela. I serve as the Provost of the University. It's my pleasure to welcome you all to this event, a panel discussion on this most important new book, Scalia Speaks, Reflections on Law, Faith, and a Life Well Lived. It's a collection of Supreme Court Justice Antonin Scalia's finest speeches covering topics as diverse as issues of church and state, Catholic education, and games and sports. We're delighted to have on the panel Mr. Edward Whelan, who is co-editor of the book. Mr. Whelan is president of the Ethics and Public Policy Center, directs EPPC's program on the Constitution, the courts, and control. His areas of expertise include constitutional law and the judicial confirmation process. He is a leading commentator on issues of constitutional law and on nominations to the Supreme Court and the lower courts. He graduated with honors from Harvard College, received his JD, magna cum laude, from Harvard Law School, where he was a member of the Board of Editors of the Harvard Law Review. Mr. Whelan was Principal Deputy Assistant Attorney General for the Office of the Youth Counsel in the U.S. Department of Justice, has served on Capitol Hill as General Counsel to the U.S. Senate Committee on the Judiciary. He was law clerk to Judge J. Clifford Wallace on the U.S. Court of Appeals of the Ninth Circuit. And most relevant for today's panel was law clerk to Supreme Court Justice Antonin Scalia. In one of the speeches in the book, Justice Scalia wrote, quote, "There are some things that must be taught at Catholic universities and some things that must not. How to use human fetuses for useful scientific research, for example, or how Mary was in fact not a virgin and Jesus had two brothers and a sister, or how artificial birth control and abortion are morally okay. Is this a restriction on free intellectual inquiry? I think not. It is simply a restriction on where it shall be done and who shall pay. If one does not believe in such restrictions, one does not believe in Catholic dogma, and one should not believe in Catholic universities." Complex questions such as these about religious liberty are very much a focus for our second panelist, Professor Mark Rienzi, who joins Mr. Whelan on the panel. Professor Rienzi is Professor of Law here at the Catholic University of America's Columbus School of Law. He teaches constitutional law, religious liberty, torts, and evidence. He has been voted Teacher of the Year 3 times by the Student Bar Association. Professor Rienzi's litigation and research interests focus on the First and 14th Amendments, with an emphasis on free speech and the free exercise of religion. His scholarship on these issues has appeared in a variety of journals, including the Harvard Law Review, Fordham Law Review, Emory Law Journal, Notre Dame Law Review, and George Mason Law Review. As a litigator, Professor Rienzi has represented a range of parties asserting First Amendment claims in courts across the country, including the Supreme Court. Prior to joining Catholic Youth, Professor Rienzi served as counsel in the Supreme Court and Appellate Practice Group at WilmerHale, and before that as law clerk to the Honorable Stephen F. Williams, Senior Circuit Judge for the U.S. Court of Appeals for the D.C. Circuit. Professor Rienzi was an editor of the Harvard Law Review and his JD from Harvard Law School and BA from Princeton University, both with honors. The panel is being moderated by Dean Daniel Attridge. Interestingly, Justice Scalia, some years ago, applied for the position of Dean of Law here at our school. He wrote, quoted in one of the speeches in the book, that he, quote, "went so far as to interview with the search committee of the faculty. But," he says, "I was wise enough even at that young age to conclude that being a law dean was indeed, as one of my former deans and mentors had described it, like running a zoo with the cages open." So zookeeper and Dean Attridge has been dean of the Harvard School of Law since 2013. Prior to that, he spent 32 years practicing law at Kirkland & Ellis. He's practiced in the area of trial and appellate litigation, handling a wide variety of cases in many different substantive areas and venues around the country. For 14 years, also served as managing partner of Kirkland's Washington office. Dean Attridge received his BA degree magna cum laude from the University of Pennsylvania, his JD cum laude from Georgetown, and where he was executive editor of the Georgetown Law Journal. After law school, he served as a law clerk to the Honorable Oliver Gash on the U.S. District Court for the District of Columbia. Please join me in giving a warm welcome to our panel.
Thank you, Dr. Bella. Appreciate that introduction. So to get us started, I wanted to turn to Ed Whelan, co-editor of the book, along with Justice Scalia's youngest son, Christopher, Could you please give us an overview of the book and tell us why you and Christopher decided to undertake this project?
Thank you, Dean Attridge. I just have to say what a joy it was for me to work on this project as someone who grieved over Justice Scalia's death, to discover this treasure trove of speeches on so many topics, speeches that are wise and insightful, and speeches that are laugh out loud funny. It was just a wonderful project for me to undertake with Chris Scalia. We had no idea going into it that there would be so many speeches of such high quality on so many subject matters. And I dare say that the universal reaction I've encountered so far is people just really enjoy this book far more than they ever imagined that they would. I want to highlight a few things about it. As Provost Abela already mentioned, the speeches cover a whole range of topics. Indeed, the very first speech in the book is a speech that Justice Scalia gave in October 1986, 1 month after he became the first Italian-American Supreme Court Justice. This was a speech that he gave to an Italian-American group, and in that speech, he reflected deeply on what it means to be an Italian-American and what it means to be American. And I think especially here in the aftermath of Columbus Day, some of his comments are especially apt. He reflected on why we, that is Italian Americans, are proud of our Italian heritage, and about why that pride makes us no less than 100% Americans. And he proceeded to go on and say that what makes an American isn't the name or the blood or even the place of birth, but the belief in the principles of freedom and equality that this country stands for. Now, two of the speeches in the book are speeches that Justice Scalia gave at Catholic University, one at a graduation in 1999, the other on receiving the Cardinal Gibbons Medal, I believe in the mid-90s. And you see in those speeches his love of Catholic University, a love that he developed when he was at Georgetown and would come up here, in part for theater, in part, I think, for social reasons. You see his description of what it was like in the 1950s. You also see how he believed that Catholic University has a special responsibility as a Catholic university, and specifically as a university, forgive me if I misspeak, under the charter of the American bishops, to stand strong and to be distinctively Catholic. And I think you see in so many of his speeches on faith, on education, his emphasis on the role of religion and moral formation. I'm going to just mention a couple other things on this far-ranging comments here. Pardon me if I'm rambling a bit, but I want to get you to get a sense of also some of the humor that animates this book. There's a wonderful speech on games and sports that Justice Scalia played in his native Queens in the 1940s and 1950s. It begins, "I have been asked many, many times, to what do I attribute my well-known athletic prowess?" And he then describes the rules of these games, stoop ball, stick ball, street hockey, and something called ringolevio. There's a speech, this is actually the second one in the book. The book starts off on talking about his speeches on American character and ethnicity. You really see his deep understanding of what the proper role of ethnicity in America is. His second speech is one that's titled "An Italian View of the Irish." This is a speech he gave on St. Patrick's Day to a group of Irish Americans. And for this, one background fact you need to know is that his wife's maiden name is Maureen McCarthy. The first appealing quality about the Irish, as seen by us subtle Italians, is their bluntness. There's very little beating about the bush with them. You always know where you stand. My wife Maureen has this endearing quality to a preeminent degree. An example that occurs to me is not really Maureen's own line, but a cartoon obviously inspired by an Irishman, which she left on the breakfast table shortly after I'd been confirmed to the Supreme Court. It shows a stern-looking, paunchy fellow sitting at the breakfast table across from his wife, reading the paper. And Maureen, the wife of the cartoon, is saying, while you are a conservative jurist who believes in judicial restraint, you are also a louse. Justice Ginsburg, Justice Scalia's dear friend, has written a beautiful foreword to this book. Justice Scalia, in turn, has a beautiful and amusing roast of Justice Ginsburg, actually then Judge Ginsburg, on her 10th anniversary on the DC Circuit. And I just want to say, I deeply believe that if you think you might like this book, you will discover that you love this book. And if you think you know anyone who might like this book, you will make that person very happy, or I should say those people very happy by getting this book for them.
Thank you, Ed. And the book is available outside for purchase if you'd like. There's a Barnes & Noble representative, so you're welcome to please go empty that table if you would. Mark, let me ask you, you're our constitutional scholar on the panel today. Did the book give you any new insights into the Supreme Court's or the Justices' constitutional jurisprudence?
So on his constitutional jurisprudence, I'd say it reminded me of something that I've known in passing, but had sort of fallen out of my head or fallen out of the way I think about things, about Justice Scalia's originalism. To me, what really jumps out when you read Scalia talking about this, several different times in front of several different audiences, is that he gets to his theory of originalism in what is really a profoundly democratic, small d democratic, in a profoundly democratic way, right? His argument for originalism when interpreting the Constitution and for doing things like ignoring the legislative history and focusing just on what the representatives actually vote for, is actually strongly driven by his idea that in a democracy, the will of the people really matters. And so he doesn't embrace the original meaning of the Constitution because he likes old ideas rather than new ideas. He embraces the original meaning of the Constitution because that's what we the people actually agreed on, and he doesn't think there's any warrant for anybody else to rewrite it without we the people agreeing to something different. And so his belief in those types of constitutional ideas and those ways of interpreting, I just thought it really, when you hear him in his own words, not in a judicial opinion, but just in a speech explaining to regular people, here's why I think this and here's why what I think actually makes a lot of sense. I just think it's fascinating how much it's really driven by, I don't know if he would ever call himself a populist. He probably wouldn't, but I read it in sort of a populist. We the people, this is our Constitution, and it's based on what the people agreed to, and therefore, even if you love the idea of what 5 justices on the Supreme Court might invent or discover next, that there's really a democracy problem with allowing them to do it. I just think that really comes out. The other thing that really comes out in the book is just sort of the full breadth of Scalia as a human being. I'm sure we'll end up talking more about that, but just reading him talk about art and opera and stickball. I mean, I grew up in the 1980s, and my main thought on reading that chapter is, wow, 1950s Queens and 1980s Staten Island, they're not that different. I played stickball, I played versions of stoopball. But just, reading him in his own words, I think people know him to be colorful, but it really just comes through in reading the speeches how colorful he is, and there's a warmth and a color and an interest to the guy that I think I knew in passing, but I never really appreciated till reading all these speeches.
All right. So Ed, any big surprises or revelations when you were doing your work on the book?
Well, again, I think the biggest surprise is how many speeches he gave on non-legal topics. I was aware that he had done some, but whether it's on civic education or legal education or hunting wild turkeys, there are so many speeches in here that, as Mark indicated, flesh out the justice in full. And I think they present a comprehensive view of someone who had a very coherent worldview. A man of deep faith, but a man whose faith told him that his duty as a judge was to say what the Constitution and the laws mean. He was quite clear, and this comes out in a number of speeches, that there were often admirers of his who misunderstood him, who thought, for example, that his criticism of Roe versus Wade was an implementation of his putative pro-life views. For starters, that reflects an error in that all that he said about Roe is that the Constitution leaves this matter to democratic processes one way or another. He never adopted the pro-life reading of the Due Process Clause that some advance. But he makes quite clear, especially in a speech called Faith in Judging, that the obligation of any judge, including a Catholic judge, is not to indulge his own religious convictions or moral convictions or policy preferences. And indeed, as he put it, the only commandment that he thought that bears on his exercise of the judicial role is the commandment that thou shalt not lie. Thou shalt not lie about the meaning of the Constitution. Thou shalt not lie about the meaning of the laws. And if there were laws that he personally thought were bad laws, he would construe them fully and fairly, just like any other law, short, of course, of a law that would require illicit cooperation and evil, in which case his duty would be to recuse from the case or even resign as a justice, but not to misread the law to mean what he would like it to mean.
The same question for you, Mark. Any big surprises or revelations when you were reading it?
On the sort of full scope of the human being, there were plenty in the way I mentioned before. But to pick up on what the one that Ed was just talking about, I thought it was interesting to read him in his own words, defending why his theory of the Constitution wasn't just a warrant for him to impose his, as he said, his so-called all the nasty conservative things that people say I want to do to the country. That's a paraphrase, but he said it's something like that. He, in different speeches, goes through different things that originalism makes him do that he would prefer not to do. And he talks about how, as a patriotic American, he loves the American flag, and if he were king, he would say no one can burn the American flag. But because he actually believes in enforcing the Constitution that we the people agreed to, he has to vote in favor of saying the First Amendment protects flag burning. He points out that how in criminal justice cases, he ends up with a lot of decisions that you would think someone who's just a law and order conservative who wants to impose his will all the time would have to be on the other side. But again, originalism makes him come out in a different way. And a few years ago, he was kind enough to speak to one of my canon law classes. I sometimes teach a class in the School of Canon Law and Religious Liberty to a group of priests and nuns who are studying to be canon lawyers. And I asked him one time, we had the same class day after day. I said, would you guys like to go on a trip someplace or do something interesting in DC? And they were like, yeah, I want to meet Scalia. I want to meet Scalia too, but we're not really doing that. One of them was like, well, one of his sons is a priest, and I think I know. I'm like, all right, you want to put in a phone call, put it in. Within 3 days, we're going to the Supreme Court to meet Justice Scalia. And this didn't make it into the book because it wasn't a public speech, but he gave a version of a similar story. He was talking about an early case that he hated deciding, where one of his early cases he had to decide involved a federal statute that dictated when a child could be adopted away from a Native American tribe. And I forget the details of it, but it was something like, whatever the result was, the thing that Congress had said to do was essentially take the kid away from the family that had been raising him for years and pluck him out of the situation he was in. And you could tell, hearing him describe it, that it really hurt him to decide the case the way he did. He hated having to decide that this is actually what the law required, but that he really felt duty bound. He felt like his obligation, the oath he swore, is to apply the law that's written. And so he's going to do that even if it's a terrible law. And I remember at that time just thinking, wow, this is not just a guy with some interesting theory about how to do it. It's somebody who is struggling to really honestly apply it, even when it leads to results he hates. And I thought that was fascinating.
Ed, as Provost Abela mentioned, you were a law clerk to Justice Scalia. I wonder if you would share some of the special moments of that experience with us.
Sure. Well, it was a great privilege to work for him. And I think what I remember above all, I suppose, is his dedication to the craft of judging. We clerks for him thought that in many ways we had the hardest task of all the clerks because we had to get every case right. It wasn't enough to figure out which way the justice wanted to decide the case and write something that got there. I clerked for him very challenging, difficult year for the court. The year that the court declined to overturn Roe versus Wade and Planned Parenthood v. Casey. And a very, very contentious year, not only for that case, but for other cases. But I guess what I remember is, especially related to the book, is how hard he worked at writing. People say correctly that he is a brilliant, talented writer. And as he explains in a speech called Writing Well, the main ingredients of good writing are really hard work, sweat and grit, and really applying your mind while you write. He would sometimes draft an opinion beginning with an intuition that X would be the result, and halfway through would conclude, this doesn't write. That's the way he would put it. This doesn't write. In other words, he would discover that through the process of trying to write out his thinking, that proper thinking would not get him to the result that initially he thought it would get to. And sometimes, he was very theatrical in a lot of ways, but I think also just had a very naturally expressive face. And I remember when he would sit at his keyboard, struggling to figure out just how to phrase something, and he would see almost like he had muscles in his head that were contorting as the gears were turning, and then it would be at the aha moment when things just, he concluded things were just right. So I think I really recall that the pride in the craft of judging, the determination to get things right, and the hard work that it took to really produce all these beautifully written opinions and speeches.
Mark, you also clerked at the appellate level. Does this sound like the typical clerkship, or something a little bit more unique?
No, I'm sure it's different and unique, and it's one. It's an experience I didn't have, but it's. I put it this way: I've spoken to other people who clerked for Justice Scalia who had very similar descriptions of the difficulty of clerking for him and the effort that was required to actually set it up the right way and how committed he was to getting it right. So I think it's probably a pretty special spot to get.
So let's talk about Justice Ginsburg for a moment. She was one of the Justice Scalia's closest friends on the court, notwithstanding the fact that they had very different views or different judicial philosophies. Could you tell us about that friendship?
Sure. This is a friendship that developed when they were both judges on the D.C. Circuit. Then Judge Ginsburg was appointed to that court in 1979, I believe. Justice Scalia in 1982. So they were colleagues for about 4 years, and they both came to like and admire each other. I think Justice Scalia really appreciated that Justice Ginsburg, then Judge Ginsburg, took the craft of judging very seriously, which, again, really aiming to get things right, and have back and forth, and they really, I think, helped to improve each other's opinions. Their friendship was deepened by their spouses, Mrs. Scalia and Marty Ginsburg. They would spend New Year's Eve together. It's a wonderful example in these polarized, divisive times of the ability to have friendships across ideological lines. And I tell you, it seems so tough in many respects in this city now. But they really provide a model, and I give Justice Ginsburg as much credit as I do Justice Scalia, for being able to appreciate the good qualities in people, being able to enjoy each other's company, while recognizing, yes, that not only do they have deep differences on judicial philosophy, but also very deep differences on moral and religious questions. Justice Ginsburg has written a beautiful foreword to this book. The last paragraph of the foreword is on the back of the book. I'm just going to read a portion of it because I think it really captures something special about the two of them. This collection of speeches captures the mind, heart, and faith of a justice who has left an indelible stamp on the Supreme Court's jurisprudence and on the teaching and practice of law. The work of his fine hand will both inspire and challenge legions of judges and advocates. If our friendship encourages others to appreciate that some very good people have ideas with which we disagree, and that despite differences, people of goodwill can pull together for the well-being of the institutions we serve in our country, I will be overjoyed, as I'm confident Justice Scalia would be. You see also in some other tributes that Justice Scalia has at the end of this book, eulogies that he delivered for dearly departed friends. This same deep fondness he had for people who, with whom he had, again, deep disagreements in some ways, but he really loved these people. And I think the short tributes at the end, in many ways, taken together, say a lot about his capacity for friendship. And again, I think it's something we could all try to emulate.
Mark, do you think the court's work benefited from the Scalia-Ginsburg?
Yeah, so I do. I think the Supreme Court generally is a more collegial place than you might expect just from reading the opinions. I think it's a more collegial place, frankly, than most of the courts of appeal. I think the justices on the Supreme Court, they obviously have deep and really important disagreements with each other all the time, but they found a way to do it very civilly and in a very high-minded way, so that even during oral arguments, when it's clear that they are essentially fighting with each other through the lawyers, there's a level of decency and civility and respect that I think must be influenced by the ability of them to actually have personal friendships and personal relationships with each other that go beyond sort of the clashing and the fighting. The paragraph that stood out to me was not really about this, but I think reflects something about it. This is Scalia talking about America as a place of people with a lot of different ideas and from a lot of different countries. One of the great strengths of this country, one of the reasons we really are a symbol of light and of hope for the world, is the way in which people of different faiths, different races, different national origins have come together and learned not merely to tolerate one another, because I think that is too stingy a word for what we've achieved, but to respect and love one another. And I read that, and he wasn't talking about his friendship with Ginsburg at the time, but I read that and I thought of his friendship with Justice Ginsburg, and similar to what Ed was saying, to me, I think, in this world, it's actually pretty easy to feel like people who disagree with you must be evil, awful, and wrong. And I think it's a great example of stepping back and realizing that, no, there's plenty of good people who hold opposite views of yours. They hold them in good faith. They're not awful people. They just disagree with you. And that their Scalia and Ginsburg's ability to put that aside, work together civilly and honestly with each other was, I think, a really good thing for the court and a really good example for all of us.
So we don't have any justices on Twitter, do we?
No, it's not openly.
No. And actually, with Judge Posner's retirement from the Seventh Circuit, we may not have any Court of Appeals judges on Twitter either.
So let's talk about the role of lawyers. Justice Scalia said in one of his speeches, and I'm quoting here, that lawyers perform the humble but essential function of establishing and preserving the social conditions that enable the work and the play of the world to be conducted smoothly, harmoniously, and consistently with the values such as individual freedom that the society considers important. Your thoughts on that?
Well, this was from a speech that Justice Scalia gave at the Juilliard School, of all places. He was on a panel with Stephen Sondheim, opera singer Renee Fleming, and the historian David McCullough. And he started off basically by saying, this panel reads like some sort of IQ test. Which of the following is out of place? Diva, author, composer, lawyer. And part of what he did in this speech was to explain that while in many respects the work that lawyers do can be regarded as very mundane, what they're doing is building a system, a rule of law that allows the arts and other things to flourish. So I think that he's reflecting on the broader vocation, the heights of the broader vocation. I guess there's this story a story that I think my wife has told, where maybe from one of the kids' book, where you can have a brick mason who says, "Oh, here I am, just working on this, just putting these stupid bricks in." And another mason says, "I'm building a cathedral." They're both doing the same work, but one understands at a higher level what he's accomplishing. And so I think that Justice Scalia very much had an understanding of work as vocation. Not everyone's vocation is going to, professionally, is going to be a Supreme Court justice, but to find what's ennobling and what's being achieved even in the sometimes mundane work that we all have to do.
Mark, your thoughts on the role of lawyers?
I think it's an important role. I think obviously there's a whole lot of lawyer jokes, as if the world doesn't need more lawyers. I tend to think if you looked at it, you think you don't like a world with a lot of lawyers, you'd really not like it if you had a world with no lawyers, right? Lawyers in many ways really do set up the structure in which all the rest of life can function. And so I certainly agree with Justice Scalia that lawyers do important work. It may not always be the highest profile, fanciest work, but when you help a family figure out how to keep their family business together after someone dies, when you help people figure out how to navigate the healthcare system, when you help people figure out how to defend their rights and live out their faith and things like that, lawyers do an awful lot of really important making the country go.
So the justice spoke about the key characteristics of lawyers. So students, you'll want to see whether you and your colleagues have them. Characteristic number one, he described as compulsive precision. For lawyers, describing a thing, anything, precisely becomes a habit, a compulsion that tends to spread into all aspects of a lawyer's life. The second characteristic, the justice said, is that must be observed a certain worldly wisdom, or if you wish to put it pejoratively, cynicism. We are so worldly wise because we have seen so much of the world vicariously through the innumerable cases we have read covering the entire spectrum of human experience. The third characteristic, he said, is our obsession with process. As a matter of fact, process is what we are all about. Your thoughts, Ed, on those three characteristics?
Well, I think those are distinctive characteristics of lawyers. They're obviously not exclusive. You can have those alone and not be a good lawyer. You need to have a fine intellect, a good work ethic, obviously a learning in the law. But I think he identifies important things that are distinctive.
I would just add something that he talks about elsewhere in the book, and that our bar examiners are supposed to be looking for, which is you also have to have a high character, right? In other words, it's not good enough just to be good at detail work. If we're doing this right, you have a high moral character and you're trustworthy and honest, and a judge can look at you and know that you're not trying to pull one over on them, and the client can look at you the same way. Obviously, a lot of the lawyer jokes, play up on the opposite traits in the lawyers who don't have them. So I think it's particularly important to add character to that list, which he talks about a lot elsewhere.
So the justice described the United States as the greatest country in the world, and he offered two reasons. Quote, "We are the greatest because of the good qualities of our people and because of a governmental system that gives room for those qualities to develop." Ed, was the justice right about this?
Well, I think we're blessed to live in a very great country. I think the justice recognized that the American experiment is one that we cannot take for granted. And he certainly understood that it's been a continual process of trying to live up to our founding ideals. Obviously, we have had grave shortcomings, and grossly understates it. He actually made these remarks in the context of a graduation speech in which he was dispelling certain platitudes, and he was explaining that too many people back then, I don't think it happens so much anymore, would just say in a cliche way, we live in the greatest country in the world. He was trying to explain in what sense that proposition can be defended, indeed in what sense he regarded that proposition as correct. And so again, what he emphasizes is that this structure of government that we have enables us to live free lives, to pursue our vocations, to have a flourishing economy. All of this, though, you see in other speeches, he emphasizes, as Mark indicated, the importance of virtue in the citizens. It's not enough, and this American experiment, he believes, will not thrive if we simply have people who are out to get what they can in a free market economy. That there is this character formation, this commitment to family and to faith that is essential. So I think that while he saw the qualities that made us, or at least the best be argued to make us the greatest country in the world, he also recognized that there are real challenges in this country. And I don't think he was at all, jingoistic about, rah, rah, we're always going to be the best.
Mark, do you think we're living in the greatest country?
Sure I do. That's easy. Let me point out two things that Scalia says along these lines that I think are fascinating. One, he points out that there is a word, that we have the term un-American in this country in a way that, like, there is no similar term, or somebody was observing to him, there is no similar term in French or in England or in Italian, like un-French or un-English. And he was pointing out that the fact that we have this idea of what it is to be un-American, and it's not un-American on religious or ethnic or racial or any other kinds of lines, it's un-American on, like, sort of insufficiently committed to freedom and equality, and our system of government and freedom and how we've set up our society. And he was pointing that out as a good thing, that we're not bound together because we're all from the same tribe. We actually sort of ended up all in the same tribe because people flocked to an idea and an opportunity. The other thing that I thought was interesting, he's got a lot of places here where he comments on what he sees in other countries. At one point he's talking about education without education about virtue or morals. And he said, like, to just think that education will always end you up in the right place is misguided. And he said the scariest thing about the Holocaust is that Germany was a highly educated place which elected their leaders democratically, right? That it's not enough to simply have elections and to simply have education. There's something more. There's a commitment to equality and tolerance and freedom that are especially important if you're going to make things end up in the right place. So I enjoyed those observations.
So I was struck, as the Provost indicated, by the Justice's comment that being a law school dean is like running a zoo with the cages open. Ed, do you think that's what I'm doing here, running a zoo?
I think the students might have a better read on that than or some of the faculty members. Obviously, being a dean is a great challenge, and I commend you for what you're accomplishing.
All right, well, thank you. Mark, assuming the law school is a zoo, what kind of an animal would you be?
I don't have a quick funny answer. But I gave you a couple days to think about it, didn't I? Still don't have one.
All right, so moving on. The Justice described his father, who taught Romance languages at Brooklyn College, as an intellectual very much committed to the life of the mind. Yet his father valued another attribute as much more important. I'm quoting the Justice quoting his father. "Son," he told me, "brains are like muscles. You can rent them by the hour. The only thing not for sale is character." Do you agree with that, Ed? Character is the most important thing?
Well, character character defines who you are. And, we're all going to face challenges in our lives. Making sure that you have developed a strong character and are ready to say no when the opportunity for evil is tempting is awfully important. You can degrade yourself through a series of bad acts. You can build yourself up through good habits. So I think you have a very Catholic understanding of what virtue and vice consist of.
I'll tell you, the line that jumped out to me most about character was there's one point where Scalia is talking about George Washington. And he's saying on another topic, let me conclude by reading a few words from the greatest American of them all, the indispensable man, the father of his country, who, by the way, was not half the intellectual of Jefferson or Madison or Hamilton, but by his force of character placed them all in awe. And there is a lesson there. I thought that was a fascinating observation, the idea that Washington, I've never read anybody saying they thought Washington was a more brilliant thinker than Madison or Jefferson or Hamilton, yet it really was by force of his character, his known excellent high character, that they all stood in awe of George Washington all the time. And I thought that was a very insightful passage right there. But yes, I certainly agree. Character is supremely important.
Justice Scalia talked about three qualities that make for a good judge: adherence to the law, scholarship, and an even-handed demeanor. Here's what he wrote. The judge must be, above all else, a servant of the law and not an enforcer of his personal predilections about the issues that come before him. The second quality is scholarship, meaning that in resolving cases according to law, the judge must be led to his answer by following the framework for neutral, objective decision-making that is dictated by the traditions of the legal system in which he operates. And the third quality is an appropriate demeanor that projects to the parties and to the public fairness and impartiality. Ed, your thoughts on those qualities?
I think this speech that he gave, I believe it was in Peru, is just on the vocation of a judge, is just a wonderful explication of the qualities we all want to see in judges. Obviously, there can be there'll be disagreements about appropriate methodology, and you want to have those arguments back and forth. But I do believe he identifies here the essential qualities.
And on that last one, the demeanor of judges, one, I think he's right that it's supremely important. I think it's a shame when judges seem like politicians, right? I think in the ideal world, our judges don't seem like politicians. One of the things Justice Scalia talks about is the nominations and confirmation process, and how really more after Scalia's nomination, but around the time of Bork, and then up to Clarence Thomas in the modern era, that judicial nominations basically, I think, according to Justice Scalia, and I think he's right on this, because of the way the judiciary had come to function, with judges at times making up what they thought the Constitution ought to say, as opposed to just determining what it actually did say, that there's a sense in which the judge's role and the way in which society views the judge changed a little bit, because if the judges are acting a little bit more like policymakers, then people will look at their judicial nominations a little bit more like big policy fights. And then what we will get is World War III over who the next judge is. Why? Because if all the next judge's job is to do is to actually interpret this document that we can all read and figure out what it means, it's not as high stakes a game as if we switch it to say the judges are allowed to add new things to the document and we're going to fight about what they are. So I thought it was interesting in a sense. He was criticizing the modern nominations process, but he was also saying, well, if this is the way the game is going to be played, if this is the way judges are going to behave, it actually makes sense that the whole country gets incredibly invested in who the next justice is, because whether it's supposed to be this way or not, if that's the source of the decision-making on the biggest issues in the country, the biggest policy questions, people are going to treat it like the next big political fight. So
He said something similar in his dissent in Planned Parenthood v. Casey. The majority in that case claimed that it was sort of tired of public protests, and it was telling people to just shut up and go along with what we're saying. And he explained in his dissent, no, it's the very fact that you've made this up and imposed it on the people that has generated these protests, and that's going to continue. And of course, he's been proven right there.
So Justice Scalia was opposed to the use of legislative history of a statute to determine the meaning of the statute. According to Justice Kagan, she viewed this as his most long-lasting legacy, that of statutory interpretation, where she said that his compelling arguments for textualism changed the way all of us think and talk about the law. Could you comment on that?
Sure. Well, I think there has been a sea change in the Supreme Court's and a broader judicial approach to statutory interpretation, to a lesser extent to constitutional interpretation over the last 30 years. Back in the 1980s, it was not uncommon to have Supreme Court briefs that were just filled with legislative history. Indeed, there was one, I think, that Justice Scalia liked to point out that said something like, having exhausted the legislative history, let's turn now to the text. Justice Kagan has said we're all textualists now. Well, maybe, maybe not. But I think there is a much greater attention to text. And look, some textual questions can be very, very difficult. To say that you're trying to figure out the textualist answer, again, doesn't mean things are going to be easy, but it does mean that you look to a whole different you look to a narrower set of materials, you look to canons of statutory construction, and I do believe that that Justice Scalia had a tremendous influence here, just as he did on originalism in the constitutional arena.
And again, what struck me when reading those passages was really the extent to which Justice Scalia's theory of textualism for interpreting statutes was really driven by his view of the democratic process. In other words, some committee's report, well, some committee may have said that, but that didn't get 51 votes in the Senate or 200, however many votes in the House. It's just a report that, some group put together, and someone's statement on the floor didn't necessarily get 51 votes in the Senate or however many votes in the House. Ultimately, what I think was driving Scalia here was this idea that the only thing that has a democratic warrant, the only thing that has power, is what actually was voted on the House and voted on by the Senate and signed by the President. And that's actually pretty small. That's just the text. Everything else is people trying to jockey about what someone will later think the text means, or as part of a horse trade about what something means, and it doesn't have the votes of the right number of people to be authoritative. And again, reading that, I feel like so often it's easy to reduce Scalia to, he just cares about text, but there's a deep type of thought behind his view that the text is what matters, that is highly democratic and highly focused on making sure that the will of the people, as expressed in the way the Constitution provides for it to be expressed, is what has to get respected.
And he also had a keen sense of how legislative history can simply be concocted, what a game it becomes for lobbyists to slip something in, just how degraded the whole thing can be. But as Mark said, at bottom, he looks at the Constitution. The Constitution says that a bill that is passed by both houses and signed into law by the President, or in the case of, or vetoed by the President, overridden, is law. Not committee reports, not other things. That is law. And this ties in, again, to his basic understanding of public meaning originalism, which unifies his statutory and constitutional views, which is, this is what the people are entitled to understand as law. Take an example. Let's say that it were shown conclusively that at the Constitutional Convention there was a secret agreement among every single member of the convention, and if you want to add it to every single state ratifying convention, that when the Constitution says that the president must be 35, the person must be 35 in order to become eligible to be president, that was actually meant in base 2 rather than base 10. Take an absurd example. This presents stark. What do you look at? You look at the original public meaning, which would have been understood by the people who adopted this, or do you look to this secret code that, again, under my hypothetical, you can show beyond any reasonable doubt this is what's intended? It's just an illustration of the democratic warrant that originalism has. I'd add as well, to build on what Mark said earlier, Justice Scalia also believed that the Constitution, when construed according to its original meaning, left broad scopes of matter to the democratic processes for decision. Again, whether it's on abortion or marriage, the death penalty, a whole list of other things. He did not claim that the Constitution imposed his views. Rather, he said that the Constitution was substantively neutral on what the democratic processes could do. And that the living Constitution, by contrast, under the guise of pretending to preserve flexibility to the political processes, deprive them of those processes by entrenching the current elite's preferences, by saying, we Supreme Court justices are going to say there is a constitutional right to X, Y, or Z, making it impossible, absent a constitutional amendment or overturning of that decision, for the people to actually revisit and revise policy over time on a range of matters. So it's not simply, though you're entirely right, it's not simply that originalism is deeply rooted in democratic theory, but also that the Constitution that people adopted is one that gives broad scope to the democratic processes.
Yeah, I agree with that, and I certainly see it. He also, he used the example of capital punishment in a few different speeches, which I thought was interesting, saying that, in his view, the Constitution clearly allows for capital punishment because it refers to capital crimes. And so, to his mind, the idea of saying that capital punishment is unconstitutional made absolutely no sense. And he liked to point out that is by far the more flexible approach. So if you say, we need a living Constitution because we have to be flexible, that's by far a more flexible answer than somebody says, we've thought about it now, and now the Constitution does make capital punishment unconstitutional. Because in Scalia's world, the answer is the Constitution didn't dictate an answer. The Constitution left it to the people. And so if you like capital punishment, vote for people who want capital punishment. Vote for people who put it in. If you don't like it, vote the other way and get people to take it out. To his mind, he was saying the Constitution sets up a basic structure. For the most part, it leaves decisions to the people to make over time. And so to say we need a living Constitution for flexibility, to his mind, was sort of a non sequitur. The proponents of the living Constitution, as he saw it, were not granting the people more flexibility to figure out stuff over the time. They were dictating the answers and depriving the people of flexibility to figure out the answers over time. And he made that point in a few different contexts, but I thought it really resonated.
Okay, I'll ask one last question, then we'll open it up to the audience to ask questions. So what do you think the biggest impact or the biggest legacy of Justice Scalia will be?
Well, I think that so long as law students and lawyers are reading Supreme Court decisions, people will be drawn to Justice Scalia's opinions, whether they agree with them or not. I think Justice Scalia has been the defining figure, was the defining figure on the court for 3 decades. Some people define themselves against him, many others define themselves with him. But I think he has really set the terms of debate, and the battle over originalism and textualism is one that will continue, and he will be very much at the center of that. I also, though, hope that in its own small way, this book of his speeches that fleshes out the justice in full, not just Scalia the justice, but Scalia the man, Scalia the Catholic, Scalia the father, Scalia the husband, Scalia the friend, will serve as a tribute to him as well.
Mark, your thoughts on the legacy?
I'll do 2. One just that I would have known without the book, and one from the book. I think it's originalism and textualism in terms of his legacy, right? He was by far the foremost proponent, the best explainer and the best teacher, the best at engaging with the other side's arguments and arguing about how we ought to interpret a constitution. And I bet a lot of money that 50 or 100 years from now, people will still be reading Justice Scalia on those topics. And I think that is an incredible contribution to his country and to the rule of law and to our society. The other thing which we didn't quite get to much in our discussion today, but that really comes out in the book, is that Justice was a man of deep faith and someone who was committed to taking his faith seriously in the world, even if at times he's got this great speech on St. Thomas More, where he talks about how More went to his death for something that was perceived by the world around him as completely silly, right? You should just sign the paper and go along with what everyone's saying. It doesn't hurt anyone. It doesn't cost anything. But he was pointing out that Thomas More did what he felt compelled to do, what he thought was right in the eyes of Jesus and his church. And so the public testimony of someone in this high in office about his efforts to live out his Catholic faith, to do it honorably, to do it in a way that engages with the world and still tries to make a mark and improve the world, I think is something that from the book I'll certainly take with me.
All right, questions? Anyone have a question?
From left field maybe, but I had the pleasure of hearing a speech by Justice Scalia here in Caldwell Auditorium in the late 90s when the philosophy department series was on the rule of law. Robert Borgholtz spoke there. The main thought I remember from that is along the lines of what you're saying, that right and wrong depends on the standard. And for the Supreme Court, that standard is the Constitution. It is not the natural law, and it is not moral law.
Okay. Someone else have a hand up? Yes, sir.
So one of the things that I really liked reading, you read the quote on the back, was Ginsburg's, appreciation for who he was. And as a young trainee to be advocate, something I'd like to have for my relationships is something similar, where you have these close relationships with people who disagree. My question is, does that closeness begin from that development of character and conviction of principle, and then that connects you with those types of people who share similarly deep levels of conviction and principle, or does it begin kind of from I'm just going to have that relationship with you, which to me kind of has the danger of maybe watering the discussion down, but I don't know, how do you practically walk that divide?
Well, an interesting question really about how friendships develop, and I would say that working together, having time together is an essential part of it. You are here now, I'm assuming you're a law student here, pardon me if you're not, in a student body that I'm sure is very diverse in lots of ways. And you will have the opportunity to get to know lots of your classmates and discover that you have much in common with many of them and much that you don't have in common. But, if they come to see your good qualities and you come to see theirs and you recognize that, you're both in good faith, trying to discern the truth, trying to discern how you will live your vocation in your life, I think you come to respect each other. Again, I think it's very sad in this city when people are instantly labeled, and it makes it really tough to develop friendships. I lived in Los Angeles 25 years ago before coming out here. I had a much more diverse set of friends there than I do here. Likewise from law school. So I would say, make friends around you. I don't think it's something that you set out to say, aha, I'm going to become a friend with this person. But there's a certain, forbearance of being, I think, too pushy at times to insist on your own way, and actually working to listen to understand someone else's point of view. Again, whether or not you agree with it, I think lots of folks will actually appreciate that they're being listened to.
Okay.
Well, the only thing I think it probably has to happen organically, and I'm no expert at making friends. My wife will tell you. Not so good socially. Bless it, she likes me. But I think it probably has to happen organically. But I think it's the kind of thing that everybody should be open to, in part because it'll make you better at talking and arguing for the things you really believe in, right? I mean, so you want to interact with people who don't see the world exactly the way you do, because you'll be pretty stilted, in your own life and your own development if you're never exposed to new ideas. And sometimes people will change your mind about something, and you'll realize, oh, I got that wrong, right? We're all fallible, we all mess stuff up. And other times you'll have a discussion with somebody, and you might change their mind. But it's a much richer life, and it's much better for developing both sort of the substance of your life and also just for thinking about how to talk to people who disagree with you. Like, you'll do no good as a lawyer if you can only talk to people who already agree with you, right? Like, congratulations, but no one needs that lawyer. No one needs to hire you. So it's just better to do it. And I think it does have to happen organically. The Scalia-Ginsburg friendship developed not because they sat next to each other in the same church, but because their offices were on the same hallway. They had to judge cases together. That's real life. That's how friendships that are not all that natural come up.
Yes, sir.
Do you think if the justice were up for nomination today in this kind of divisive climate, he would be confirmed?
Yeah, 98-0, just like the first time. No, I think it would be World War III. I think if he were up when Bork was up, it would have been World War III.
Yeah, again, Justice Scalia was confirmed 98-0 in 1986, and Judge Bork was defeated 58-42, I believe, the following year. The decisive fact that explains the difference was that Democrats won control of the Senate in the November 1986 elections. They did not have the ammunition to go after Scalia, and in fact, they chose to go after Rehnquist, who had been elevated to chief in 1986. So, as Mark suggests, it's not clear that Scalia would have been confirmed in 1987. I wasn't say much less now, except now we have a Republican control of the Senate, and although it required abolition of the filibuster, which never been used before, to get Justice Gorsuch through, I would think that something similar would have happened with someone like Justice Scalia, which again highlights the basic point for understanding the politics of judicial nominations fights, that who has the majority of the Senate is the most important fact to pay attention to.
Okay, I think we have time for one more question. Anyone have a question? Yes, go ahead.
I'm curious as the civic British parliamentarian system works, probably because it's not just because it's parliamentarian, but it's British. What Scalia brought in so many ways in demeanor and intellect and caliber and just how he conducted himself to the court, in part worked because it's Scalia. And I wonder if there's not a hazard to that. The legacy might lead for a certain degree of intensity engagement, the outspokenness, and so on. That's an artful thing to pull off. If you don't have this high degree of wit and intelligence and character, it can come across simply combative. And I'm just curious what I think of that.
So are you speaking now of his style of oral argument? Is that?
I'm sorry.
Are you speaking of his manner at oral argument, or?
Well, in part, but his willingness to speak out in public, the vigorousness in his opinions, and so on.
Look, there's no question that he acquired a lot of enemies in the process as well. That's I'm not going to deny that. So different people have different judgments as to just where to draw the line. I think Justice Ginsburg has earned a lot of criticism in recent years for seeming to talk very openly about pending cases and political matters. So I think there is a real challenge to determine just where the line ought to be drawn. Ultimately, that line shouldn't depend on a justice's temperament or manner of speaking, but certainly some justices might aggravate more than others.
All right. Okay, the book is Scalia Speaks. If you haven't bought a copy, please buy one. Mr. Whelan will be happy to sign yours if you bring it on up, I hope.
Absolutely, and wonderful Christmas gift for your parents, your siblings, your cousins, your grandparents, all your friends. Dude, that's the best way to make a good friend here. Buy a copy of Scalia Speaks.
Please join me in thanking Mr. Whelan. Will you sign mine? Of course.